Hello, America. Hello, Massachusetts. Today we're going to talk about why gun laws are an illusion. To keep and bear arms, Massachusetts. Presented to the American people on 16 March 2019. The Table of Authorities. We begin with the United States Constitution, the Massachusetts Constitution, the Declaration of Independence, the Massachusetts General Laws, the Code of Massachusetts Regulations, selected Supreme Court cases, and a case from the U.S. Court of Appeals, in addition to Black's Law's Dictionary. In the beginning, the United States Constitution declares, "The right of the people to keep and bear arms shall not be infringed." And the Massachusetts Constitution declares, "The people have a right to keep and bear arms for the common defense." The state's statute books at Chapter 140 authorizes a license which shall entitle a holder thereof to possess and carry firearms. Are not the rights secured by the Constitution separate and distinguishable from the entitlements authorized by license? In contract law, a license gives permission to do an act which would otherwise be illegal, a trespass, or a tort. The license to carry firearms is authorized according to the terms disclosed by statute. A person enters into said terms by application, a $100 fee is paid in consideration, and acceptance of the contract is indicated by the signatures of both the applicant and an authorized agent of the state. The United States Supreme Court teaches that our statute books, such as the legislated statutes of Massachusetts, are acts authorizing the making of contracts with the government. Therefore, the license to carry is plainly a contract authorized by the state legislature. Contracts are, of course, voluntary and require consent. As the Supreme Court went on to say, the person entering into such a contract must see for himself that his contract comes within the terms of the law. A contract does not infringe upon the Constitution. It merely offers an additional entitlement separate from the rights secured by it. In this case, a license to carry entitles a holder thereof to carry, and carry means to transport for hire. That is, transportation is the removal of goods or persons from one place to another by a carrier. Hence, carry is what a carrier does for hire. Much like nurses are licensed to nurse, doctors are licensed to doctor, accountants are licensed to account, plumbers are licensed to plumb, importers are licensed to import, professionals are licensed in their professions, carriers are licensed to carry. In fact, the state issues several types of carrier licenses. For example, a motor carrier is licensed at MGL 64F, a contract carrier, a common carrier, and an agricultural carrier are licensed at MGL Chapter 159B. Also, public air carriers engaged in air transportation for hire are subject to the rules of MGL Chapter 90, and hazmat carriers are regulated by 540 CMR 14. Therefore, it is only natural that a firearms carrier is required to have a license to carry. But there is no license to bear arms. The licensed entitlement to possess and carry firearms are different from the right to keep and bear arms. The terms of entitlement must not include the rights secured by the Constitution. As the United States Supreme Court has ruled, statutes are to be construed and applied in harmony with, and not to thwart, the purpose of the Constitution. And where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Consequently, there is no written legislation, statute, or even judgment which technically infringes upon the right of the people to keep and bear arms. A word search of the federal and state statute books, including thousands of pages of text, confirms that the term arms, as it refers to anything that a man wears for his defense or to cast at or strike another, is not the subject of any restrictive or controlling regulation. This observation is consistent with the United States Supreme Court decisions, as it has ruled that the legislature cannot invoke the sovereignty of the people to override their will as declared in the Constitution, and that the legislature cannot, by any definition it may adopt, redefine the terms, since it cannot by legislation alter the Constitution, from which alone it derives its power to legislate. Thus, the term arms is never defined in any statute and is completely excluded from the subject of government control. Although not defined and thus excluded from regulation, the term arms is nevertheless recognized on several occasions by the Massachusetts State Legislature. In MGL 269-4, officers may require the aid of persons in arms for suppression of riots and seizure of persons. MGL 149, Section 177, allows assisting with arms in the defense of property. And MGL 62C, Section 55A, exempts arms for personal use from state tax levies, in recognition that the state cannot infringe upon a right by taxation. The people's right to keep and bear arms is the original subject matter secured in the Constitution. In order to weaken these protections, a century of legislation have used customized legal terms, such as carry, to evade the stated intent of the Constitution by circuitous and indirect methods. Another such specialized term is firearms, which do not ordinarily apply to the people. It is fact that all firearms are arms, and there are only two kinds of arms: those belonging to the people and those not belonging to the people. Since we already know that the government is constitutionally prohibited from infringing upon the people's right to keep and bear arms, it follows that only the firearms not belonging to the people can be subject to the legislation. Indeed, firearms are defined by and in Part 1 of the Massachusetts General Statutes, which is plainly entitled Administration of the Government. The United States Supreme Court instructs that title confines the operation and effect of statutes, and words of universal scope will be construed as meaning only those subject to the legislation. And however broad and general its language, it cannot be interpreted as extending beyond the constitutional power of the legislature to reach. Thus, firearms can only mean those firearms pertaining in some way to the administration of the government, and absolutely excludes the arms belonging to the people, which are neither defined by statute nor within the constitutional power of the legislature to reach. It is commonly presumed that a man with a gun is either licensed to carry or that he is illegally carrying a firearm. But a third option is self-evident. He may be merely exercising his right to keep and bear arms as secured by the supreme law of the Constitution. This is an inherent liberty of all Americans, as clearly inscribed on and declared by the Franklin County Courthouse in Greenfield, Massachusetts, to wit, law secures liberty without license. Here is the Franklin County Courthouse, and inscribed in the center, you see, law secures liberty without license. I take that as a public message. We already know this from experience. There is no such thing as a license for free speech, or a license for religion, or a license for the press, or a license for the freedom of association, or a license for any other constitutional or natural right. So what evidence is there for a license to keep and bear arms? The United States Supreme Court has already settled this question. A state may not impose a charge for the enjoyment of or a license tax on the exercise of a right guaranteed by the federal Constitution. Thus, the burden of any prosecution is not only to show that the accused did not have a license, but moreover that he exceeded his lawful right to keep and bear arms, for which no license exists. In other words, the due process right to the presumption of innocence must primarily maintain that the accused was not required to have a license when the state cannot license a right, and when the claim and exercise of a constitutional right cannot be converted into a crime. Another fundamental right to be considered here is the due process requirement to be informed of the nature and cause of the accusation. A prosecutor for the Commonwealth must fully and plainly, substantially and formally describe the facts and subject matter giving jurisdiction to the court. Specifically, the prosecutor must reveal what a statutory firearm is and how it is distinguished from the arms secured by the Constitution, arms for personal use described in MGL 62C Section 55A, and arms as defined by the United States Supreme Court. He must clearly define the commercial entitlement of carry, which means transport for hire, and how it's distinguished from the constitutional right to bear arms. And he must also clearly define the statutory entitlement of possess and how it is distinguished from the constitutional right to keep. After all, a criminal statute worded in terms so vague that men of common intelligence must guess at its meaning and differ as to its application lacks the first essential of due process of law. In summary, it is our right to keep and bear arms. There is no license to keep and bear arms. The government cannot tax nor infringe upon your arms for personal use. If you carry, such as in transport for hire, then you must get a license to carry. If you possess a firearm, then be prepared to serve in the administration of the government. Thank you for watching. Please like, share, and act. Do your part to keep and bear arms. Bear arms forever. Thank you.